The 14B District Court is now in session. My name is MIWashington, and I'm the judge that will be presiding over this session. The court will call the case of the State of Michigan versus Keela Jones, case number 23-00513.
Good morning. McDuffie for the people.
Good morning, Assistant Public Defender Sandra White on behalf of Keela Jones.
Ms. Jones, if you could have them unmute you so you can state your name, please.
Keela Jones.
Thank you. All right, we're here for a pretrial and bond violation in this matter. Ms. White, I received your mitigation statement this morning, and I just finished reading it. So where are we with this case, please?
Yes, Your Honor. We are asking the court if you would grant HIDA for Ms. Jones if she was to plead guilty.
What is your position on the HIDA request, Ms. McDuffie? Please remind me.
Your Honor, I wasn't opposed to it initially, but then Ms. Jones was violated with a new offense that she has pled to and is awaiting sentencing in 14A2. She failed to report for testing, so she had a bench warrant for that as well. And then there was a new thing, but that was a denied warrant. So I'm concerned, obviously, but I would also say that I have read the mitigation statement as well, and I can understand how Ms. Jones is starting off on the wrong track, and her circumstances are not helping that. So I defer to the court in terms of granting HIDA. I'm concerned about how she's going to do no matter what type of sentence she has, quite frankly.
Thank you. Well, here's the thing. The mitigation statement is obviously moving. Her actions are concerning. They almost cancel each other out. Because the reality is that given all that she's been through, my hope would be that she would choose a different path. And she is not doing that so far. So what I'm willing to do is to give her HIDA, but that doesn't mean she's not going to get additional jail time until she figures this out. So HIDA does not negate jail time. So I will grant HIDA, but I'm not saying that I won't do more jail time. I'm willing to give her an opportunity to have a clean record in the end, but she needs to do better. And simple discussions is not changing her attitude or her behavior. So maybe some jail will. That is where I am, Ms. White. What would you like to do?
I guess I need to speak with Ms. Jones.
Okay. Put you on a breakout room with Ms. Jones.
Thank you.
State of Michigan versus MIWashington, case number 24S4321387.
Rachel McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Mr. Mozeb. Mr. Mozeb, can you unmute and state your name, please?
Good morning. My name is Mubarak Mozeb.
Good morning, sir. All right, we're here on this driving while license suspended matter, I believe. I'm in receipt of screenshots.
Yes, Your Honor, these screenshots were sent just as verification that Mr. Mozeb did submit, right? Mr. Mozeb, you submitted your appeal packet, but I believe just yesterday, right?
Yes, it took a little while to get the letters from various people that were required for this submission.
Yes. So he's been waiting for that, so he has submitted it now. And so if there is a possible offer from Ms. McDuffie, we would be asking for hopefully a last adjournment so he can get a hearing date and we can see the outcome of that appeal process.
Ms. McDuffie?
Yes, so we adjourned last time because it sounded like it was not until March 28th. We adjourned till May because that was when he was eligible to apply for the appeal, and we adjourned to see if he had a hearing date. So it looks like from these screenshots, he submitted this was it last night?
Yes, that's what they said.
Okay, but he doesn't actually have the date yet.
That's correct.
I'm sorry.
Oh, I'm sorry. I just said that's correct. No date yet.
Okay. My only concern is we kind of had this issue come up earlier this week with someone else who sent in an application, but it was incomplete. And then they were notified that they hadn't actually applied. And so because all we have is that he submitted his application, I at least want to know that the application is complete, correct, and that they will schedule a hearing. Because I don't know what was uploaded. I trust that Mr. Moseb did the best he could and probably did fulfill the requirements, but I just need to have the hearing date at the least to know that they have everything they need.
Absolutely.
July 11th, 2024 at 9 a.m. to see if we have the actual hearing date by then. So we'll see you then, sir, on July 11th, okay?
Okay. Thank you all. Have a good day.
Thank you, you too.
Thank you.
State of Michigan versus Kobe Garcia, 24S00084.
Rachel McDuffie for the people.
Good morning, Your Honor. Assistant Public Defender Davia Lieb on behalf of Mr. Garcia. Mr. Garcia, could you unmute and state your name, sir?
How you doing? I'm Kobe Garcia.
Thank you. Please turn on your screen, sir. Thank you. Good morning, sir.
Good morning.
All right, we're here for a pretrial today.
Yes, Your Honor. We did receive an offer from Ms. McDuffie this morning that would like to request an adjournment in order to discuss it with our client.
Okay.
Pretrial in this case will be adjourned to June 27th, 2024 at 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Welcome, sir. Have a good day.
Have a good day.
Thank you. State of Michigan versus Regina Brown, case number 24 FB 1088.
Rachel McDuffie for the people.
I'm sorry, I apologize, Your Honor. I misread it.
Okay,
It
one
should have been
second.
at 10 a.m. for private.
Your
attorneys
attorney's not here yet, so give us one moment, ma'am, okay?
Okay.
Thank you. That's
Uh,
okay. State of Michigan versus Darius Prince, case number 23S00408.
Rachel McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Darius Prince. Mr. Prince, can you unmute and state your name, please? Mr. Prince, your video just went off. If you,
Yep.
oh, there we go.
Yeah, I'm here.
Please state your name, sir.
Darius Prince.
Thank you. Right, in this particular matter, we are here for pretrial today. The defendant was here on May 16th where he was told at that time to continue his ETG testing and to return here. And we would be here for a pretrial and potential bond violation today. I got another updated violation report, but I do also have some documentation in here through May 16th. For the ETG testing. So he's been testing at on-site.
Yes,
That
Your
is
Honor.
correct.
Your Honor, do you see on the test results, mine go all the way up to May 28th?
I do not have that. I have through May 16th.
Okay, I can forward you what was sent from on-site to probation yesterday. I'm sorry, I'll forward that right now.
Thank you.
And if somebody could share with me, please, I have nothing.
Oh, sorry, Ms. McDuffie, I'll send that now. We were just, this was last minute, it came through on-site. It said they had faxed it last week, but I don't know if it didn't come through, so they emailed it directly to probation yesterday. I just sent it to everyone now.
It has not come through yet, in case you're wondering why we're all
Oh, oh no, I'm sorry.
Oh, you sent it only to Heather.
Oh, sorry, Judge, I can send it directly. Do you want me to send it directly to you as well? I'm sorry, I just am in the habit
That's
of.
okay, we're printing it. All right, this one I do have for.
You gotta mute me.
Okay, I have it now, but I don't. Oh, I see. They sent it to the lab and these are the lab results showing. We had a positive back on April 8th, and that's the only positive that we've had thus far. And he
216.
report. I'm sorry?
216 as well. He was arraigned on 214.
I see. Yes. Positive for alcohol. And then he did not report for testing on May 20th or April 30th.
I've reported, I have not missed a date.
Well, all I'm telling you is what the report says, sir.
Your Honor, I have not missed a date. I did miss going in one afternoon because I had to work and I couldn't get off, but I followed up the next day.
Your Honor, I would, and I'm sorry, kind of in the busyness yesterday of we do know how we would like to resolve the case. So Mr. Prince and I discussed that, and we were trying to track down the results. I didn't speak with him about the results. If I could speak with him briefly in a breakout room about the positives and the missed test. Like I said, we do know how we're resolving the case. Mr. Prince will be pleading as charged to the offenses today.
I'll let you talk to him about what he wants to do with respect to the violations for the 2 positive ETG tests. And
Okay.
Any explanations regarding what they're saying on this test.
Okay, thank you.
Thank you. All right, the court will recall the case of the state of Michigan versus Keela Jones, case number 23-00513.
Originally deputy for the people.
Assistant Public Defender Sandra White on behalf of Keela Jones.
Keela Jones.
Thank you. All right, what would your client like to do today, please?
We have discussed Your Honor's offer, and Ms. Jones wishes to accept that HIDA under those conditions, understanding that there will be jail time.
Sure. All right, so, ma'am, it's my understanding you're going to be pleading guilty to assault and battery. That is a misdemeanor carrying a maximum penalty of 93 days and up to $500 fine plus court costs. The court has indicated that, which I am the court, that I would be willing to give you HIDA on this particular case, but with some upfront jail time, which you've already begun serving some of that time. Is that your understanding of the agreement?
Yeah, yes, ma'am.
Please raise your right hand to be, and is that what you want to do?
No, you didn't need to. No, you didn't need to.
Is that what you want to do, ma'am? To accept the plea?
Yeah,
Other right hand, please. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? So help you God.
yeah,
You said a yes.
yes.
All right, thank you. You may lower your hand. I'm going to go with some rights you have, Ms. Jones, that you're going to be giving up by entering into this plea. Please stop me if you have any questions, or if you feel like you want to speak to your attorney again, okay?
Okay,
You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. You have the right to be a witness for yourself, or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand that?
yes,
Do you understand you're going to be giving up all those rights and you're not going to be having a trial of any sort?
yes,
Do you also understand that there's no automatic right to appeal this decision? So what that means for you, ma'am, is once you enter into this plea, in all likelihood, this is the plea that is going to stick with you. And the only way you can get this off your record is by successfully completing the HIDA program. Do you understand that?
yes,
And do you also understand that if you were on probation, parole, or bond, when you committed this offense, you could be violated of that probation, parole, or bond? And this happened on September 24th, 2023. Were you on probation, parole, or bond on that particular date, ma'am?
no,
And then finally, if you're not a U.S. citizen, you could have immigration consequences. Are you a U.S. citizen?
yes.
To the charge of assault and battery, how do you plead?
Guilty.
Has anyone promised you anything other than what we placed on the record here today to get you to plead guilty, Ms. Jones?
No,
Anyone threatening you in any way, shape, or form?
no.
All right. On or about September 24th, 2023, were you at the vicinity of 2931 Roundtree Boulevard, apartment number 2?
Yes,
And while you were there, was Dominique Harris there?
yes.
That's your brother?
Hmm?
That's your brother?
That's my baby daddy's
Your
sister.
baby daddy's sister.
Yes,
Oh. And did you assault or batter your baby daddy's sister?
yes.
What happened?
We were into it, and well, she had hit me, and then she hit me and she ran in the room, so I ran in the room and I assaulted her.
So you ran behind her and then you hit her. What did you do?
Like
You say you assaulted her. What did you do?
Well, I hit her, like we were fighting.
So, Miss White, it sounds like it was interesting. So she hit you and then she ran.
Yes.
How long before you chased her? Like, did you chase her immediately?
Like I waited for my mama to look away and then I ran in there. So like a minute.
Oh, I see. Okay. All right. I find that there's a factual basis for the plea. It has been willingly and knowingly made. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Ms. White?
Satisfied, Your Honor.
All right. So what's this other case that she has? Can you tell me about that, please? Ms. McDuffie?
Yes, her the newer 14A2 case is also an assault and battery against a different person that does not, I shouldn't say doesn't appear to be connected because the relationships could be, anything, but this is somebody who reported getting off the bus when they got sprayed with mace.
Oh, she sprayed someone with mace?
Yeah.
When did this happen?
On February 9th, 2024, when Miss Jones was out on PR on this case.
All right, because I arraigned her for let's see. Got arraigned by Magistrate Nelson in September. And then I got a bond violation report that I did nothing with. Then on October 26th, she failed to appear. And then she got a bench warrant for failing to appear. Then she came back before me and I arraigned her on January 24th. No, she came before the magistrate. That's the magistrate's handwriting. Magistrate Braley this time. And then she appeared at the pretrial. Then that was February 5th. And so you said this happened on what day?
February 9th.
So in between the pretrial that she was here for and the next pretrial on March 4th, she sprayed someone with mace.
Your Honor, if I may.
And then you will in a second. I'll let you in a second. And then she came back on March 4th. That's when we modified the bond to allow her to have contact with Latara Jones. Is that?
That's her
Her
mom.
mother. Her mother.
Okay. All right. So now you may.
Miss Jones admits that, as you know, this was her first offense, and she didn't understand the seriousness of everything. And she has been sitting for 30 days, and she understands, and she's had a lot of time to think and talk with me. She does want to start anew, and I have already told the court, we were in my mitigation statement a lot about her. She wants to show herself and the court that she can make a change, and hopefully she can do it. And I understand that the court wants to give her more jail time, but hopefully not as much as less or more than.
Well, clearly she's violated terms of her bond. She had a whole new case that she has pled to.
Correct.
She, after I modified her bond, something happened on March 6th. And she got a new bench warrant. Ms. Jones needs counseling. I mean, it's very easy to put in a report all these things and ideas that we sometimes superimpose on what people should be doing. I don't know whether this comes from you or comes from Ms. Jones, to be honest. What I do know is that her background is sufficient enough for me to want to give her some additional chance. So that's why I did it. But the whole hope for her brother and the hope for her, his attorneys know how to word things so that it appears that our clients want what we think they should be doing. So I don't know if Ms. Jones gets it. That's what my concern is. Is she involved with CMH at all?
I don't believe so. Miss Jones, are you with CMH?
And here I am.
Okay.
Your Honor, can we approach really briefly? I have a
You
question.
can, you may. Yeah.
They in the break room again. The
Okay, we're back on the record in the Keela Jones matter. Ms. Jones, it's my understanding that you may be able to go live at your uncle's.
Okay, I apologize.
It's okay. It's my understanding you may be able to go live at your uncle's.
Yeah, he wanted me to come stay with him when I got out of here so I could get myself together.
If he is willing to do a home confinement tether there, then I would consider that. There are some obligations and requests and orders that I have for you in the meantime. You need to have a signed contract with CMH before I will release you. So you need to be under their care. Now, once you get out, if you can find a different place for you to go and get some counseling, you can switch to that. But in the interim time period, you need to have a contract with CMH before you can be released. I'll release you to home confinement to your uncle once we get the address and the name of that individual. You then need to look for a job and get signed up to get your GED and your diploma. And those things need to happen by the time you come back here for sentencing.
Okay.
Okay?
Okay,
Uh,
how would I have a question?
Yes, ma'am.
Okay, how would I give you guys the information on like the address and his name and stuff?
I'm gonna put you in a breakout room with your attorney as soon as I'm done. Okay?
Okay.
All right. So I'll see you back here on June 27th at 10 o'clock a.m. for sentencing. Okay?
Okay.
We won't be able to release you until we have that address and name, but as soon as we have that, I'll give you an opportunity. Please see it as that, Ms. Jones. The behavior that you've been exhibiting, and know you think it's normal, you probably have seen a lot of it, but that's not acceptable behavior. And it's not all your fault. Some of this is learned. It's what you've been around, it's what you think is okay, but it's not. Do you understand that part now?
Yes, ma'am.
And I hope I don't want you to feel like I'm scolding you. I'm trying to get through to you. I want you to be the best version of you can be. And you got to get in a different environment to do that. Okay?
Okay.
All right, ma'am. I'm hoping and wishing you nothing but the best. And I hope that you believe that and believe that you can be better and do better so that everything that White wrote about what you want for you and what you want for your brother can come true. Okay?
Okay.
All right. I'll see you here on June 27th. Okay?
Okay. Thank you.
Thank you. All right. State of Michigan versus Brenton Warren, case number 24 FB 1101. You're muted, Ms. McDuffie.
Rachel
Good morning,
McDuffie. Sorry about that.
I'm sorry, Miss McDuffie. Good morning, Your Honor. For the record, my name is Jeffrey Bennett. I'm appearing with and on behalf of Mr. Warren today. Mr. Warren, could you state your name for the record, please?
Brenton Warren.
Thank you. Good morning, Mr. Bennett, and good morning, Mr. Warren.
Good morning. How you doing?
I'm good. We're here for a pretrial today.
Yes, Your Honor. We're just asking for a jury trial date.
And I'm sorry, Your Honor. I was going to give my normal spiel. Mr. Bennett, I don't recall if we worked together before, but just so that you know, I see a request, some communication with the complainant in this case and a request for a particular resolution. I just wanted you to know that my policy is generally that when things are set for trial or final settlement conference, which is a request for a jury trial or for a bench trial, all offers are off the table at that point. So I encourage everybody to A, make sure they have complete discovery, and B, have had an opportunity to confer with me and consider any potential offers, because they will not be available after that point, because setting something for trial to me indicates that you have understood the complete lay of the land and you wish to basically go forward, foregoing all that. Since we haven't spoken, I just wanted you to know that in case you would like to request a final pretrial so that we could do that. If not, I just wanted you to have that understanding first.
So are we able to discuss a resolution before the final settlement conference? If I go that way?
So it would be a journey to a final pretrial. The final settlement conference is where we are
Okay.
fully proceed.
Well, we can do that. I will listen to the offer, but I'm not sure if we'll be able to have a resolution. But I will reach out to you to find out what the offer is.
Understood.
All right, final pretrial in this case will be on June. Does June 20th work with your calendar?
Your Honor, I'm going to be on a vacation from June 15th until June 28th.
Okay. I can put it out 1 week. Otherwise, I think it's way too far out because my next court date wouldn't be until July 11th, and I'm not moving it that far out. Are you here next week on June 6th, Mr. Bennett?
Well, if I can appear by Zoom, could we put it on the 27th
Yes.
of June?
You can appear by Zoom. June 27th is a better date. June 27th, 2024 at 9 a.m. Bond is continued. It is via Zoom. They're all via Zoom unless.
Yes, I keep forgetting that you're a Zoom judge. A lot of it's in person. I'm going to be driving back from Phoenix, so I will take a suit.
All right. Thank you. All right.
Thank you, Your Honor. Have a good day. Mr. Warren, I'll reach out to you, okay?
Okay.
State of Michigan versus Regina Brown, 24 FB 1088.
Rachel McDuffie for the people.
Good morning, Your Honor. Nicole James, appearing on behalf of Ms. Brown.
Hi, good morning, Regina Brown.
Thank you. Good morning, everyone. Today's day and time scheduled for sentencing in this matter. Have you had an opportunity to review the pre-sentence investigation report with your client? If so, are there any additions, deletions, or corrections to be made?
No. Yes, Your Honor, I've had an opportunity to review that with Ms. Brown. There are no additions, corrections, or deletions. Judge, I would only ask, I know that there is a recommendation of community service. Ms. Brown is asking the court if you would consider waiving that provision. She is starting work again. She does have to make that restitution, and she just wants to be able to make sure that she can work enough hours to satisfy the restitution amount.
I guess I would need a little bit more information. I understand obviously that everything takes time, and so she wants to be able to work, but the community service can come in a lot of different forms. So I guess I need a little bit more insight on what she's doing that would prevent her from potentially doing community service as well. I given the recommendation.
I don't get any more insight. The reality is that she's doing, she's not getting probation. So she's going to do the community service. So my request to you was, do you have anything you want to say about the sentencing otherwise?
Oh, generally, sorry about that.
That's okay.
Related to the overall recommendation, my understanding is that Ms. Brown, I think, is one of 3 co-defendants in this underlying case. And after reviewing that, I believe what she said about getting kind of caught up with something and somebody that I think she didn't was reluctant to get involved in. I see that she doesn't have any history, and I do think that it's a fair recommendation. So nothing further from the people.
Thank you. Anything further from you, Ms. James?
Judge, I would just indicate that Ms. Brown has taken responsibility for her actions in this matter. I believe that on the report, it indicates that she paid $500 towards the restitution. There was a $50 payment that was made to an attorney's office on behalf of that steward that was provided to the Mr. Ganatra. And I told Ms. Brown she's probably going to have to provide that to the probation department as well. So it should be $550 that's already been paid.
Is that correct, Ms. McDuffie?
Your Honor, I believe so. I saw some correspondence, but unfortunately I don't have it handy. But I do believe that there is those funds were already paid.
All right, thank you. Ms. Brown, is there anything you'd like to say, ma'am?
Yes, I'm sorry. I'm take full responsibility for my actions. This is not me. I don't do stuff like that. I've never been in trouble before, and I really don't want this to ever happen again. I'm sorry to the court. I really want you to know I've been really doing childcare for the last 20-something plus years, and I can't go back to my childcare. Once this is resolved with you guys, I apologize to you, your court, and I just want to say I accept my responsibility. I'm sorry to the people and to the persons that I did this to, and I will never be in trouble again in my life. This is not me at all.
Thank you very much, Ms. Brown. I really appreciate what you had to say, and I appreciate what you had to say in the report too. I believe that the recommendation is actually fair, and you know, on some levels, you may be a part victim yourself. I think your mistake was in believing that it might be something wrong with it and then still following through. Financially, though, sometimes we put ourselves in positions where we get desperate and make desperate decisions that have negative consequences. So I am going to follow the recommendation. It is the sentence of this court that you serve 365 days in jail, credit for 1 day served. The whole entire balance of that is suspended. So you don't have to do any jail time as long as you just complete these tasks. You're not going to be on probation or anything like that. So that's why I think you doing some community service is important. I am going to order some community service. What I will do for you is knock some of the days down, so it won't be the full amount. Instead of the 6 days, I'm going to give you 4 days.
Okay, thank you.
You're welcome. Fines and court costs in this particular case for a total of $395, $1,205 in restitution, $500 posted will be applied to the restitution, and then you'll provide proof of the $50 to be applied also. $30 per month. There is no probation, so there is no oversight fee, so that's not applicable. You will complete the Crossroads Recovery Program, Retail Fraud and Crimes Prevention course within 90 days, and we'll do a review in 90 days to see if we've done those things. Okay?
Okay, question, how would I, okay, I'm putting on the record that I have to be moved, so could I have a little time because I'm in the process of moving back to Washtenaw County. I'll be moving in on June 6th. I get my keys. So when would this other stuff take place?
You have 90 days to get your class done, ma'am. So your next date would be until August 29th.
My next court date is August 29th?
Correct.
Okay. So, will I get information from the courts on where I go for the class?
Yes. I'm gonna give you a phone number right now to call tomorrow after 9 o'clock. And anybody else on the call needs to write down this phone number also.
Okay.
In case you get referred to probation and you don't have the probation phone number.
Okay. Okay.
Your pen, ma'am?
Wait 1 second.
Okay.
Okay, I'm putting. Okay, what's the number?
734. 483. 7336.
This is probation?
Yes, it is.
Oh, can I contact them? All right, thank you.
No problem. Tomorrow after 9. Good luck to you, ma'am, and I'll see you on August 29th, okay?
All right, thank you.
Judge, do you need me to appear at the review date?
That is between you and your client as to whether or not you retain to appear or agree to appear or whatever that looks like.
Okay, thank you.
Ms. Brown, if you've done it, Ms. Brown, if you've done everything you need to do by then you will be done with this case. That's what that boils down for you, okay?
Okay, thank you. Have a blessed one. Bye-bye.
All right, thank you. Have a good one, everyone.
Bye-bye, Miss Jane.
Okay,
bye-bye.
Bye-bye.
recalling the matter of the state of Michigan versus Darius Prince, case number 23-00408.
Rachel McDuffie for the people.
Assistant Public Defender Allison Mueller here on behalf of Darius Prince. Mr. Prince, can you state your name again, please?
Yes, Darius Prince.
Thank you. What would your client like to do with respect to the bond violation?
Your Honor, he does admit to the violations of the two positives and the two missed tests. We would like to provide just context as far as the missed tests go.
Thank you. Mr. Prince, please raise your right hand to be sworn. I'm sorry, I don't see your right hand raised, sir. Mr. Prince, can you hear me? Do you swear or affirm that the testimony you're about to provide? Yeah, you have a delay. That's what the problem is. Do you swear or affirm that the testimony you're about to provide would be the truth, the whole truth, and nothing but the truth?
We're breaking up. Breaking up, Your Honor.
Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. Sir, you have a right to have a hearing regarding the bond violations. It's my understanding you're going to waive that right and you're going to admit to violating your bond by testing positive on two separate occasions, April 8th and February the 16th of 2024, and then also failing to report for ETG testing on April 30th and May 20th. Is that correct, sir?
Hello? Excuse me.
Could you
I
hear
didn't
me?
catch what. I can see you and hear you now.
This may not work out, Ms. Mueller. I'm gonna try one more time. If it doesn't work, then we're gonna have to do this on a different day where he may need to come into court.
Okay.
Okay. So, sir, can you hear me now?
Yes. Yes.
All right. You're gonna admit to testing positive on April 8th and February 16th and failing to appear to test on April 30th and May 20th. Is that correct?
Correct.
All right. Thank you. I find that there's a knowing and willing admission to the violation. We'll take all the satisfactions at the same time. My understanding is he's also going to be entering into a plea today.
That's correct, Your Honor. Mr. Prince will be pleading as charged. I believe there's not an offer on this matter, and I did discuss with Mr. Prince about his license. It sounds like it'll take significant time for him to have a valid license, and so I advised him I don't believe we'll be able to adjourn out as far as he needs to have a valid license.
Thank you. So, Mr. Prince, my understanding is you're going to be pleading guilty to operating while intoxicated, driving while license suspended, revoked, or denied, and having alcohol in open container in the motor vehicle. Is that correct?
Yes, it is.
All right.
But it wasn't in the front seat.
So 1 second, 1 second. We're not quite there yet. I got to advise you of some rights before you get to that. This is a process. It's a fairly lengthy process, maybe lengthier because you can't hear me half the time. So, as to the operating while intoxicated, that is a misdemeanor carrying a maximum of 93 days and up to $500 fine and or 360 hours of community service. Do you understand that, sir?
Yes, I do.
Plus court costs. Count 2 is operating while license suspended, revoked, or denied. That is a misdemeanor carrying up to 93 days and or $500 fine plus court costs. Do you understand that?
Yes, I do.
And I'm sorry, this is the second or subsequent offense notice. Is that that's going to be applicable to Ms. McDuffie?
Yes, Ron.
All right, so that means that this carries up to 1 year and or $1,000 fine. Do you understand that part, sir?
Yes.
Okay. And then there's open alcohol container in the vehicle that carries up to 90 days and or $100 fine plus court costs. Understand all those penalties, sir?
Yes, I do.
All right, you have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself. or you can choose to remain silent. If you choose to remain silent, the prosecutor cannot comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights, sir?
Yes, I do.
You understand you're going to be giving up each and every one of those rights, and you're not going to be having a trial of any sort.
Yes.
Right. And if you were on probation, parole, or bond when this happened on January 5th of 2023, you could be in violation of your probation, parole, or bond. Were you on any of those on that date?
No.
All right. And if you're not a U.S. citizen, you could have immigration consequences. Are you a U.S. citizen, sir?
Yes, I am.
On January 5th, 2023, well, first of all, to the charges of operating while intoxicated, operating with license suspended, second offense notice, and alcohol open container in a motor vehicle, how do you plead?
Guilty.
Has anyone promised you anything other than what we placed on the record to get you to plead guilty?
No.
Has anyone threatened you in any way, shape, or form?
No, they have not.
All right, thank you. On January 5th, 2023, were you operating a motor vehicle at the vicinity of Rossville Road and Grove Road here in Ypsilanti Township, sir?
Yes, I was.
And while you were operating that motor vehicle, were you under the influence of alcohol?
Yes.
All right. And were your license suspended, revoked, and denied while you were driving?
They were suspended.
All right. And had they been, you've been convicted of driving while license suspended in the 45th District Court on or about October the 11th of 2013, and then in the 43rd District Court and on or about October 18th of 1995?
Those cases were not me. I know who did it. Somebody, I know who did it. Because I was living in Alabama at that time.
You were living in Alabama in 1995?
Yep.
In 2013?
2013, I was here. But I know who did both of those.
Well, did you do the one in the, let me see, I might have this backwards. So in 2015, you were in the 45th District Court. Did you do that one?
What court was that? If I may ask.
I don't know. Ms. McDuffie, do you know?
I can help, Your Honor. So there's a 15, 2013, and 95. I have the ROA in front of me for Oak Park. So that is a guilty plea by Mr. Prince, the driving with a suspended license that was entered on May 28th of 2015. That's in the 45th District Court.
Oak Park?
Oak Park, Michigan, yes.
Was that you, sir?
Yes.
Okay, I have enough. I don't need to go into the details about the other one. So, thank you. And then finally, sir, you were gonna tell us you had an open container of alcohol in the front seat of the car, I think is what you said earlier. Is that correct?
No, it was up under the seat.
It was under the seat, but it was open?
Yes.
Okay. And what was it?
Brandy.
Oh, yeah, some brandy. Okay. All right. I find that there's a knowing and willing plea of guilty to all three of the charges as well as to the bond violation. Are you satisfied, Ms. McDuffie?
Yes, Ron.
Ms. Miller?
I'm satisfied as well, Your Honor.
Well, one more thing I think I missed. Was there a BAC in this case?
I have a .131, Your Honor.
Thank you. Now I'm
Yes.
satisfied. Are you
Defense
satisfied?
stipulates that and is
All right.
satisfied.
All right. Sentencing in these matters will be on July 11th, 2024 at 10 a.m. Sir, did you write down the phone number when I handed it out earlier for the probation department?
No, I didn't. I don't have a pen on me.
Well, you're gonna need to call the probation department So you might want to write this down unless Ms. Mueller can text you or something.
Yeah, Your Honor, I can text, Mr. Prince, I can text you the number.
All right, because I'm at work.
All right, bond is continued.
Well,
So
Your
you
Honor, I'm sorry, Your Honor, as to bond, because he did admit to the violations as well. I wanted to request, given that we have the positives, I'll save my commentary for when he's sentenced, but that Mr. Prince may need a sober link at this point rather than the ETGs. So I did,
No.
just a moment, Mr. Prince, just a
Prince,
moment.
please don't interrupt. Anything else, Ms. McDuffie?
well, yes, I guess I will say this one thing. When we were here on April 4th, I made a note to myself that Mr. Prince sounded like he was intoxicated on the record, and that I wanted to see his testing results. And then we've been going around trying to get those. So it
All right, let's stop. We need you to stop.
Okay.
Intoxicated.
Hold on, please.
Satisfied as well, Your Honor. Well, from Ms., it was literally right after Ms. Mueller said that she was satisfied, Your Honor, that it cut. So it was when you went to Ms. McDuffie to ask if she was satisfied and she started speaking.
Yes, Ms. McDuffie first.
Okay, so then I'm sorry, I was fast forwarding to try and hear it. So I did get Ms. Mueller
And
being
you
satisfied
got
as
the
well.
BAC.
I did not get the BAC. It was once Ms. Mueller. I mean, it might be. Was it beforehand, Your Honor? Because I was speeding through to try and make sure that of what we got or not. I mean, if they could
It was
say
all
that,
in the midst of
if
that.
they can be the say the BAC again.
All right, we need to make sure that the BAC is on the record. It may have stopped before then. My understanding is the BAC is 0.13, correct?
0.131, yes, Your Honor.
131, and you stipulated to that, Ms. Mueller,
I did, Your Honor.
and we are satisfied with the plea, correct?
Yes.
Yes.
And you were making a motion, Ms. McDuffie, to add a sober link.
Yes, Your Honor. So given that Mr. Prince, we are also satisfied, I know the court wants to do them all together, satisfied with his admissions for the bond violations with the positive and missed results. My concern is that I made a note to myself on April 4th that Mr. Prince appeared, at least to me, to be intoxicated. He sounded like he was drunk to me when we were on the record on that date, and that I wanted to look at his test results. And it's taken us a lot of doing to try to get those. We finally got them today. And I'm almost not surprised to see the dates of those positive results on April 8th. He has a positive right after he was arraigned on this case and given his bond conditions, and then another positive result a few days after he appeared in court on this case as well. I think that given that, that it may be time for him to get on a testing method that will allow us more immediate access to those results, because I'm concerned that we have positives at all, obviously, and that they've taken place after he's been seen by this court, days after he's been seen by this court twice now.
Thank you. Ms. Mueller, a couple of things. One, you needed to provide me with an explanation as to why he missed several tests. And then two, you can respond to Ms. McDuffie's request.
Thank you, Your Honor. So for the April 30th, he did miss that. He works in maintenance. He sometimes works late. That night he was on call. I believe on-site closes at 7:30. He worked after that. when he reminded me, he did let me know of that situation. So I can at least verify that that's the reason he provided me at the time. It's the same reason he provided me now. Same reason on May 20th, where he missed. I did want to just show that he did go the next morning at 5:37, I believe, right on the 21st. So he missed on the 20th due to work reasons, but came very, very early the next morning to make up that test. So he did miss. The one time he did try to make it up as soon as possible. I understand the concerns. I do. It has been since April 8th, the last positive. So that does show, at least since that date, a good track record, at least of negatives since then. And for that reason, just for the recent weeks of testing and all negatives, I would ask the court at this time to leave the testing in place. It seems like Mr. Prince has found his rhythm with on-site. He can't miss anymore, and he knows that he's got to get to on-site. He can't miss because of work, and he's aware of that. So at this time, I would ask the court to leave testing as it is. And of course, if there's more violations, I understand that the situation would change. But at this time, I'd ask the court to leave it in place.
Thank you. All right, Ms. McDuffie, I hear you and I heard your request. At this point, I'm gonna leave the bond conditions where they are, Mr. Prince.
Thank you.
Mr. Prince, if you have another missed test of any sort, if we don't get these results in a timely fashion, if you have a positive test, you're going on to the server link at a minimum, if not jail time. Do you understand?
Yep.
Okay. And I'm doing that because the last result was back on April 8th, and we're almost a month and a half out from that. I'll see you back here on July 11th, sir. You need to contact probation tomorrow after 9:00 a.m. and schedule a time to have your pre-sentence investigation report done, which includes having an alcohol assessment. If you miss that appointment or anything else, then you will be going on server link. Okay?
Yes. Thank you, Your Honor. Thank you, everyone. Everyone have a good afternoon.
Thank you, sir.
To Mr. Prince.
State of Michigan versus Gary Moore, 24B 1040.
Rachel McDuffie for the people.
Good morning, Erica Julian for the record on behalf of Gary Moore. Gary, can you have someone unmute your system there and identify yourself?
Morning, Ms. Julian.
Good morning, Your Honor. Good morning, Ms. McDuffie.
Good morning.
Oh.
Your Honor, while he is being unmuted, may we approach briefly?
Ah. Okay.
All right, we're back on the record for the sentencing with the Gary Moore matter. Is there anything you'd like to say on behalf of your client, Ms. Julian? I understand we don't have a report in this case, but I intend to follow the agreement that has been made to sentence him to the mental health treatment court with the 15th District Court.
Just if he could identify himself for the record first. Gary, can you state your name now that you're unmuted?
hear it a lot more.
Yes, Your Honor. I don't have anything further on behalf of Mr. Moore. I think this is a great resolution for this case, and I think it will help Mr. Moore get back onto his feet and get some stability with some housing and medication and the things that he needs.
Thank you. Anything from the people?
Nothing from the people.
All right, Mr. Moore, anything you want to say today, sir?
No, but thank you.
You're welcome, sir. It is the sentence of this court that Mr. Moore be sentenced to 1 year in the Washington County Jail with credit for 95 days. The balance is suspended upon successful completion of the 15th District Court Mental Health Treatment Court. Well, he needs to remain in custody, I should say. He's to remain in custody until his official sentencing into the program, which is going to be on June 12th, 2024 at 1:30. It's my understanding that the Mental Health Treatment Court is a 2-year program. He must complete that, or they will have the opportunity to give him the rest of the remaining time after his official sentencing and on June 12th at 1:30 p.m. Fines and court costs in this particular case for a total of $375. They will institute their own probation oversight fees, which I believe are $30 per month. So defendant is remanded until the June 12th, 2024 court date.
Thank you very much, Your Honor. Gary, you're going to be seen by the mental health court. So you're going to stay in the jail until June 12th. And then by then they will have met with you and they're going to work out your housing and your medication and getting a support structure for you. And other than that, Gary, I wish you the very best and I hope that you succeed. Okay.
Yeah.
All right. Thank you. You're all
Thank
set.
you. Thank you.
State of Michigan versus Devion Ellis, case number 23 FB 1258.
Rachel McDuffie for the people.
Ms. Mueller?
I'm sorry about that. Your Honor, I'm sorry, which case was called?
Mr. Ellis.
Excuse me. Assistant Public Defender Allison Mueller here on behalf of Devon Ellis. Mr. Ellis, can you state your name, please?
Devon Ellis. Good morning, Your Honor.
Good morning, Mr. Ellis. All right. We're here for another arraignment on a violation of probation. Mr. Ellis, it alleges that you, 1, failed to submit proof of your 12-step meetings as ordered, failed to sign a release of information with Don Farm for the probation agent, Ms. Straub, failed to complete the MAD victim impact panel within 45 days of sentencing. And those are technical violations. The non-technical violation is that you failed to report to probation for over 60 days. With the non-technical probation violation, sir, you could be subjected to the original maximum penalty, which in this case is up to 1 year. The recommendation at this time is for you to do the 5 days that you should have done before that I held in abeyance because you told me you were going to get it together. And then an additional 10 days for a total of 15 days in the Washington County Jail. Your client is entitled to have a hearing on this matter, at which time, if it is shown that he did violate, he could do the maximum penalties in this case. What is your client's position with respect to the hearing?
Your Honor, we will not be requesting a hearing. Mr. Ellis does admit to the violations, and of course, I would just like to speak on his behalf.
Of course. Ms. Ellis, please raise your right hand and be sworn. Do you swear or affirm that the testimony about the provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Sir, is it true that you failed to report to probation for over 60 days, failed to complete the MAD victim impact panel, failed to sign a release of information with Don Firm, and failed to submit proof of your 12-step meetings?
Yes, but I think I did fill out something for Down Farms.
Ms. Mueller?
Your Honor, it seems, and that's in the report as well, it's a little unclear what's happened with Don Farms. Ms. Straub also wrote in the report that it seems like he's done something with Don Farms, but we were admitting as far as it seems like at least he hasn't signed an ROI to her. I'm a little unclear Mr. Ellis is also a little confused what has and hasn't happened. I would like a chance to speak with Dawn Farms to see what's going on, what the disconnect is. And so I hope that's something we can resolve very soon, but it does seem at this point that at least our probation has not received the information they need to receive.
Ms. Straub has unmuted. Good morning, Ms. Straub.
Good morning, Your Honor. So I did speak with Don Farb. It sounds like he signed a release of information for someone. I don't know who that person is. But because it's not to 14B or to me directly, they can't give me any information. So I don't know what he has done there. But it sounds like he has at least contacted them for something. I just can't speak to what it is.
Well, why don't I accept the violations as to this 12 step, the VIP, and the failure to report? Ms. McDuffie, are you satisfied?
Yes, Your Honor.
Ms. Mueller?
I'm satisfied, Your Honor.
All right. Any further explanation you have on your client's behalf at this time?
Your Honor, not so much an explanation. I'm not sure what the disconnect is. I wish I understood it because it would help me help a lot of clients. And I think I appreciated Ms. Straub's report. I think as she said, it seems like he's doing the hard parts. He's been negative for all substances, it looks like, since February. And I mean, that's pretty awesome. I don't know what's the disconnect about reporting and doing the MAD victim impact panel. When I spoke to him about that just now, he said something that made it clear to me he was confused about that wasn't something else. And so I recommended to him, and I'm sure this should have been done sooner than today, but I said, I think it would be helpful for you to really sit down with probation. I'm sure they have explained these things several times, but maybe just one in detail, another conversation. But it's of course his responsibility. He needs to be doing these things. He needs to be checking in with probation. He needs to be submitting his proofs. He has been going to 12-step meetings. He brought his sheet in last time when he was in person. He goes to the King of Kings off Packard. He's looking at switching to a place closer to him that he said sounded interesting, but he doesn't have the proof. It hasn't been submitted, but he is going. But he has not done the MAD victim impact panel. He's not been reporting. So that's certainly not okay, but I do think that he is on the right track, doing a lot better, especially in regards to substances, which to me is the most important part of all of this. Not that the other requirements are not important, but I don't know what to say as far as the recommendation. I know what was said last time, and we agreed to that the 5 days was suspended. I'm not sure that the 15 days in jail will, maybe it shows some, maybe it causes him to take this more seriously, but I don't think it's for him not taking it seriously. I think there's some kind of disconnect. I'm not sure what is causing that, but I would, for that reason, I guess, ask the court to not follow the recommendation, or to, I would ask for less time. I don't think 15 days is needed. But of course, my request would be that he not serve jail time, and that he understand he has to do this if he wants to continue on probation.
Ms. McDuffie?
So that time was held in abeyance because at the time he had missed so many tests that we actually didn't know really where he stood. And I'm going to assume, and I think accept that the fact that he has been testing negative also means that he hasn't missed any either. So that's definitely a huge improvement from where we started as it relates to that. But the abeyance was for any violations, I believe, as well. Mr. Ellis generally appears before the court in a state of confusion, and he may need some assistance. I guess he probably does, but at the same time, I think, as his own attorney just mentioned, like, we can't hold his hand. Nobody can through every single thing he needs to do. Some of these things are just the low-hanging fruit, as I often say, which is reporting to probation online, or even there's been some cases where arrangements have been made where people can call when they aren't able to use computers very well. 12-step meetings. It's important. I understand that it was a challenge and a problem for Mr. Ellis to test as he should, and I'm glad that that's been, but it's almost as if he can only do one thing at a time, right? Where there's one thing he can do to comply, but then everything else falls to the wayside as a consequence of that. And unfortunately, he has to learn how to do all the things he needs to do and get whatever resources and help he needs to do it. So I will say this, Mr. Ellis, I've mentioned it a couple of times. His new case has been authorized. He does have a new felony offense coming. And it is not a violation on this case, because it was actually before he was even arraigned on it. So it wouldn't even be a bond violation, let alone a VOP, but he should know that he has a OWI third and controlled substance case coming. It's not processed yet. I signed that a couple weeks ago, I believe. So that is something he's going to have to deal with as well. On top of this case, he has a whole new offense he has to resolve. So I hope that Mr. Ellis gets connected with whatever he needs to get it together, because it's going to get even harder moving forward. Does he need to go to jail today? I don't necessarily think so, but he's going to end up there because this is not going to get any easier unless he gets it together.
All right, what would you like to say, Mr. Ellis?
That I've been trying. I'm still dealing with CMH, but I'm like, I'm not making any excuses, man. And I've actually feeling better now that I'm off drugs and alcohol, and my body's more healthy, and I don't see me going back to doing drugs and liquor, nor anything illegal, because you guys have gave me opportunity, and I just want to keep on staying positive and following y'all directions.
Thank you. Can I talk? Can I see everybody in a breakout room, please? Mr. Ellis, I'm going to schedule
Yes,
you
Your Honor.
I'm going to schedule you to come in for in-person sentencing. You need to work with your attorney to give her any proofs regarding your 12-step meetings and get that ROI in place before you get here. Okay?
Yes.
Please do all that stuff and work with her so she can make sure we can understand what's going on with CMH too, and any past trauma you've had. We want to understand it all. Okay?
Okay.
All right. Do you want to go into a breakout room before we let him go, Ms. Smoller?
That would be great, Your Honor. Yes, thank you.
I'll see you back here on June 27th at 11 a.m., sir.
Thank you, Your Honor.
You're welcome. State of Michigan versus Joshua Gordonier, case number 22S00943.
Richmond, for the people.
Assistant Public Defender Sandra White on behalf of Joshua Gordonier.
Thank you.
Joshua Gordonier.
Hello, Mr. Gordonier.
Hello.
Thank you for your patience today. You've been sitting here patiently watching all these people who messing up, and you got it together, huh?
No problem.
So it looks like you have submitted your 12-step meetings for April, completed an assessment at GrowthWorks, and you're supposed to be getting outpatient today.
Stop.
1 second, please. Okay.
You're back on the record. I apologize.
All right, you may proceed.
It's actually next Thursday, Your Honor.
Next Thursday, okay.
Yes.
And you have not, but you haven't submitted any monthly report forms. What is up with people? I don't understand. This is the easy part.
I did submit it, and I even sent a picture of my AA things. I don't understand why she didn't get it, because I went to ipsy.org township. I went to the probation check-in. I filled everything out and hit submit. I've only done it once. I did miss a month, I guess, is what Sandra White told me yesterday. But
Okay.
I won't miss another one. I did do it. I'm sorry that I missed it. I'm trying to do everything.
I understand. Okay, so make sure you go online tomorrow and do a report, okay? Or
Yes, ma'am.
today. We'll do
Okay,
that.
yes, ma'am.
We're gonna switch you from Scram over to the Sober Link. So
What is that?
you blow in it twice per day.
Okay.
More if you actually test positive, you have to blow more than that, but it's a reduction in what you're doing. If you want to stay on Scram, you can do that, but this week, if it's a device, you carry it with you and you have to blow on it, blow into it twice per day, and it registers whether you're using alcohol or not. Okay. And then you need to submit your 12-step meeting attendance for May, and we'll continue you on your probation.
Yes, ma'am.
And I'll see you back here in 90 days.
Okay, thank you.
That is going to put us over to August 29th at 10 o'clock a.m. Okay?
Thank you very much, ma'am.
See me before then, that's not a good thing. So
I understand.
All right. Thank you. Take care of yourself, Mr. Gordonier.
You too. Bye-bye.
Bye-bye. We have more 10 o'clocks I need to do before we switch to the 11s.
I need to put Mr. Wade in with Ms. Mueller, who just came back.
Okay.
And then I guess we could let in the few people I can't figure out who they are, and I can try and call Ms. Barnwell since she's not here for Mr. Biggins' motion.
All right, Mr. Wade's going in with Ms. Mueller. Yeah, let's bring him. No. Okay.
So Papa Bear's still connecting.
Gotcha.
I also have an HMD Global Nokia.
Okay.
So everyone else who's in there, I was able to identify with a little bit of information that had.
The device labeled HMD Global Nokia C300 that just connected. Please unmute and tell us your first and last name.
Moss. Stephen Moss.
Hello, Mr. Stephen Moss. We'll relabel you on the screen. Please remute yourself, sir. Is that a?
One of the 11 o'clock.
Okay.
Yes.
The individual with the name of Papa Bear, please unmute your device and tell us your first and last name. Papa Bear? Please turn on your screen, sir. If you don't respond, you're going to be removed from the courtroom. And if you're not here for your court date, you will get a bench warrant. Last call for Papa Bear to tell us your name, turn on your screen, or you're going to be removed from the court. All right, remove Papa Bear. Go ahead.
Oh, he signed out on his own.
It's not my problem. That's his and his attorney's.
So we're just gonna hold it.
Yeah. Yep. No, I'm gonna take a bathroom break and then we'll start my 11 o'clock. All right, we'll start 11 o'clock in just a few minutes. Let's take a brief bathroom break for 3 minutes and we'll return. All right, the 14B District Court is now back in session. The court will call the case of Eddie Wade, case number 22 FB 1339.
First, definitely for the people.
Assistant Public Defender Allison Miller here on behalf of Eddie Wade. Mr. Wade, can you have them unmute you and state your name, please?
Eddie Wade.
Thank you. All right, Ms. Mueller, I guess we're still awaiting the outcome of the other case. What's the status of that case?
Your Honor, Mr. Wade said his next court date is June 3rd, but he does believe new charges are being authorized. So it sounds like it might be kind of going backwards once those new charges are authorized. So that's what's happening with the case.
New charges in that case, or is he getting a separate case with new charges?
I believe within that case, but new charges. Correct me if I'm wrong, Mr. Wade.
Yeah, I mean, it's new charges with that case. Prosecutor said that she wanted to charge me with delivering manufacturing meth. They found one pill.
Mr. Wade, don't say anything, please, about
Okay.
the details, but you can say what you're being charged
Yeah,
with.
that's what the charge was.
All right, thank you.
Your Honor, this was an issue because I think that some labs or something like that had not come back when it was initially charged.
I see. All right.
But I did complete down farms like y'all asked. I did do that in the jail. I'm in the MRT class that was recommended.
Are you, sir? Okay, that's good.
Yeah, so
What's his bond on the other case?
$100,000 bond.
100,000. Okay.
I mean it's $100,000 on the case, yeah.
Cash or surety?
Yeah.
Okay.
Yeah.
Well, I'm gonna put it over to June 27th
Okay.
and see where we are then.
All right.
Thank you, sir.
Yeah, thank you. Have a good day.
You too.
Yeah, I'm done.
All right, let's begin these final settlement conferences. We can let everybody in.
Sorry, Your Honor. Warner threats. My phone been acting weird.
You're Papa Bear, huh?
Yes, ma'am.
All right.
My daughter's named it that.
All right. When you come to court, you need to change that, Mr. Threats, okay?
Yes, ma'am.
All right. Good afternoon, everyone. I was waiting for everyone to get connected before I started my process here. We're here today for what is called final settlement conferences. This is the day in which we find out whether or not the cases are going to be proceeding to trial. So I think everybody here has pretty much been here before, unless you are a witness. But what you need to do is make sure that your files, your cases, that you're muted. I'm sorry. You're muted until your case is called. Once your case is called, then you can unmute yourself. If you are a witness, we'll let you know when it's time for you to be excused from court today. So the way it works is the attorneys will be working in the background to see who is present, who is not present. We've tried to name everybody already. So a part of what you were waiting for was for us to finish our last docket and to get everybody named who had come into the courtroom without their name being listed. As soon as the attorneys provide the recorder with the fact that the case is ready and with what the request is going to be, whether it's going to be a proceeding to trial, whether it's going to be a dismissal, whether there's going to be arguments over adjournment, whatever that process is going to be, the recorder needs to be notified of that so she can let me know what we're doing. So as soon as you're ready to go, please let the recorder know. Why is Miss Hilton here? Is she on the matter?
She's a witness for one of the settlement conferences.
And I know her from landlord tenant docket, so I just was wondering what was going on. Thank you. While we wait for final settlement conferences to get in order, I'm going to call the case of the state of Michigan versus Warner Threats, case number 21S00413.
Richmond Deputy for the People.
Sorry about that. Assistant Public Defender Sandra White on behalf of Warner Threats.
All right, Mr. Threats, you're here. Can you state your name again, please? You need to unmute, sir.
Warner Lee Threats Jr.
Thank you. Mr. Threats, you told me you were going to be making $150 per month. We talked about this and you told me you could afford this. I remember this conversation.
Yeah,
But
yeah, yeah.
and you're supposed to be making that on the first of each month. How's that been going?
I had some. I rather let my attorney speak. Like some
Okay.
unexpected things happen.
All right, Ms. White, go ahead.
Yes, Mr. Threats unfortunately had some unfortunate financial thing come up, and he just went back to work 2 weeks ago. So he is asking for his payments, number one, to be reduced significantly to $25 a month.
A big difference.
A very big difference. He needs to catch up on everything. And Mr. Threats, you said you hope you should be able to get started making payments again next month.
Yeah, I actually spoke to I go to work at 4 o'clock and I already spoke to the owner. He's going to give me an advancement on it just so I can try to get my court thing, the court stuff over with.
Oh, okay.
Yep. I spoke with him last night after I spoke with you.
Okay. Okay. Let's not make a big commitment again, though.
No. I trust me.
Okay.
I understand. Especially
Okay.
being a single dad, like I didn't think things were going to go the way that they went, but I'm still,
Okay.
But I can tell you what I'm willing to do. I'm not willing to go down to 25. I'm willing to go down to 50.
Okay.
So, okay.
That's fine. Appreciate it.
And I will bring you back here on August 29th.
Yes, ma'am. That's perfect. I'll have something done by then. I promise.
All right. Thank you. Take care of yourself, Mr. Threats.
You too. Thank you.
State of Michigan versus Kadena Jackson, case number 23S00353.
Richmond Deputy for the People.
Assistant Public Defender Sandra White on behalf of Kadena Jackson.
Ms. Kadena Jackson, please state your name. Is that a miss? I can only see orange. Kadena Jackson, please unmute your device and state your name.
Chicken. I'll get the chicken in a minute. Stay right here. That's it.
Jackson? Miss Jackson,
Yes, can y'all hear me?
you're in court, ma'am, and I need for you to act like you're in court.
Yes, ma'am. I apologize. I was trying to get back to my phone. Can everyone hear me okay?
Yes, please state your name.
My name is Kadena Jackson.
Ms. White?
Yes, Your Honor. We would like to proceed to jury selection on this matter.
Your Honor, the people are ready to proceed as well. That is the case that Ms. Hilton is here on. Thank you so much, Ms. Hilton, for appearing. But I brought to Ms. Ashley Jordan's attention quite some time ago that I believe there's a potential PD conflict on this case. This is related to a matter that took place the day before where the PD represents the complaining witness, and that person would be the witness on this case. So I don't
I'm
know
sorry,
what.
can you repeat that for me again?
Yes. Miss Ashley Jordan, who at one point I think was in our court working with the PD's office, I had brought to her attention a while ago that I believe there's a conflict on this case. So this matter that we're here on is related to a separate case that took place the day before, where a victim or witness in this case is a defendant in another matter with Miss Jackson. And that case is very closely related to this matter, and he would potentially be a witness in this one. And so I brought it up a couple of times. I don't know if it was ever looked into or if that was run through the conflict check and came out clear, but I don't know that we can go any further unless I can confirm that that's been okayed, I guess.
I'm sorry, that wasn't in any of the notes. If we want to pass this matter, I can look into it. I can at least look and see if he is a conflict, and then we can maybe take it back to pretrial stage so that we can withdraw if necessary.
I'll pass it.
And is Ms. Hilton okay to be excused at this point?
Yes, she is.
Thank you. Thank you, Ms. Hilton.
Yes, please. Ms. Yarmolenko, please call your client and have them get connected.
I did, Your Honor. She's not answering, but I'll keep trying.
Because he's going to. He's one of them. No, it's not. Oh, okay. There was a report. Where I don't know. It's not in the new papers. Did bring in the criminal history that's.
I'm sorry?
She brought in that criminal history that I texted Brian. So if you can go ahead and have a seat at that table over there for us, that way you can see everybody else on the Polycom further.
This goes on how to do anything.
Oh, no worries.
I'm gonna help him out.
Oh, okay. Yeah, that's fine.
All right, the court will call the case of the state of Michigan versus Tommy Clark, case number 23 FB 1373.
Rachel McDuffie for the people.
Good morning, Your Honor. Charlotte Steffen on behalf of Mr. Clark.
Tommy Clark.
Thank you. All right, we're here for sentencing on violations of probations today. He pled to the violations on April 9th, and I scheduled it for in-person sentencing today. I'm sorry, April 9th. I'm not sure what date I just said.
Yeah.
And I ordered that he must get an assessment done, and he's on the Sober Link now. And it looks like he hasn't had any additional violations on that Sober Link. Is that correct? Ms. Steffen?
Oh, yes, Judge. I'm sorry. I wasn't sure who you were speaking to. I have not received any specific reports, but from talking to my client, it sounds like he's doing very well, Your Honor.
All right.
I'm pulling up the Sober Link report as we speak right now, Your Honor, and I'm forwarding it to everyone.
All right, thank you so much. Did he get the assessment done that was supposed to be done?
I was currently I was already assessed to a class that I was going to. So when he told me that, I did go talk to Ms. Johnson, and she referred me to a lady, but I believe she called me back and said, don't worry about it, since I'm already in a class that I was assessed for.
Who called you back and said, don't
Ms.
worry?
Johnson.
He's currently doing the CCLP program right now.
Okay.
So we held off on it, provided he didn't have any additional positives, and right now he doesn't have any additional positives.
I see. Thank you. So has your recommendation changed from the April 9th report?
I'm pulling up that report right now, Your Honor. So right now we'll continue him with the CCLP and the Sober Link and reporting and see where he's at. I will hold the jail in abeyance at your discretion.
Anything from the people?
Nothing from the people.
All right. At this time, sir, I will continue you on the Sober Link, continue your probation, and hold the jail time that we have in abeyance. 5 days in the Washington County Jail is held in abeyance. So there will be no additional jail on this particular case at this time. Is there anything else that I need to know about or do today, Ms. Johnson?
He does have an outstanding felony warrant that he needs to be detained on, Your Honor.
So,
What?
walked in on that yesterday.
What's the felony warrant for, please?
He with.
Possession with intent to deliver?
Yes, Your Honor.
I believe I gave the copy of that warrant to the court earlier this day.
When did they issue the warrant?
1 moment, please. You have a bench warrant for failure to, no, that's not it. 1 second.
I think it's the third one on the list, Your Honor.
Thank you. Oh, okay. It's like the 4th or 5th one. He has a number of warrants, actually. There's a warrant for felony for dangerous weapons. Remarks. Controlled substance delivery, manufacturing, meth. Possession of narcotics. Entered on in lien on May 3rd.
I'm calling y'all, baby, where I actually think so. Where it was.
There's also a warrant for disorderly person from airport.
Promise.
Yes.
Yeah, I know about the old ones. The deal.
Battle Creek bench warrant.
Those are driving too.
Yeah, traffic offense. Same for Woodhaven. And yeah, there's one for Dearborn that you just mentioned.
I paid the other ones off. My license back, and I just established.
The problem is that this case.
This is the one that you guys was aware about, right? That could pop up.
I don't know. I don't keep track of them. Maybe the prosecutor does. But
If you guys was telling me one might pop up.
that might have been the prosecutor, like I said.
I did
Because they
mention
would,
this.
I would not be aware of anything that might pop up because they don't come to us first. They come to the prosecutor's office. But yes, this is the one for the count 1, controlled substance delivery manufacturer, count 2, controlled substance possession of narcotics, less than 25 grams. And apparently it arose here in Ypsilanti Township. So technically I can't allow you to walk in here and not arrest you on it because it's a 14B matter. So please.
Where do I go to court on?
Do you know how that works, Ms. McDuffie or Ms. Johnson? What will be his next court date? I think it's tomorrow.
He hasn't been arraigned on it yet, so it looks like, let's see here.
Right. When will he be arraigned is what I'm asking.
Can I get into that?
So I can't speak to that part. He needs to contact 14A1 and request an out of custody arraignment, obviously. He may be able to do that, but I can't speak to, how and when that works.
I think once you're in custody, sir, you go the same day. So it won't be today. It wouldn't be until tomorrow. So I think you have to be in before 8 a.m. to go today, unless things have changed. Do you know any additional information, Ms. Johnson?
I do not know any additional information, Your Honor.
Any way you guys can find out?
I'm sorry?
Is there any way you guys can find out?
Well, this is why I brought it up, that it was coming, because
Right, and I would have turned myself in like you guys said, but nobody told me when I was calling in.
I didn't hear that last part, but
He said that he would have turned himself in if he had known, but no one told him about it when he was calling in.
I could have did that yesterday.
to our court? He was calling
No,
in.
to 14, I don't know where you
I was calling in here, my probation and my attorney.
Okay, yeah, I can't speak to that. I try to tell people things are coming so that they don't get surprised, but that's all I can do.
But y'all said the one came out May 3rd.
Yes, that is correct. Sir, you need to go.
No, I'm going. I just, yeah. Come on.
See a warrant, I mean, a bond that you could post that no amount has been determined. Or I would allow you to post that, but it's not in here.
All right. Will my car not be towed?
No, it won't be towed. Ypsilanti Township versus Menage Brown, case number 24T00122.
Paul Barnett on behalf of the township.
And Edward Drukas on behalf of Menage Brown.
All right, we're here today for a final settlement conference in this matter.
That's correct, Your Honor. At this time, the township is not in a position to proceed to trial.
I'd move to dismiss, Your Honor.
Ms. Menage Brown, did you say your name?
Monasia Brown.
Monasia, sorry. Ms. Brown, given that the people are unable to proceed, I'm gonna grant your attorney's motion to dismiss this without prejudice. Meaning that if they're able to proceed at a later date and time, they could reauthorize. This case is now over. All your bond conditions are now over, but you should not have contact until, did she leave? Oh, no, she's there. You should not have contact until after 5 o'clock today, ma'am, okay? Because that's we put in lien to remove the conditions.
Yes, ma'am.
Have a good day.
Thank you, Your Honor.
Ypsilanti Township versus Trevante Thomas, case number 23W002240.
Paul Barnett on behalf of the township.
Edward Drucas on behalf of Trevante Thomas.
Good morning, Your Honor. Tom.
Good morning, sir.
Mike.
We're here for settlement conference in this case.
That's correct, Your Honor. Pursuant to an agreement where he pled in another case, we're moving to dismiss this case.
Thank you. Case is now dismissed, sir. You're all set. Have a good day.
Yes, ma'am, too.
Thank you.
Ypsilanti Township versus Joshua Clerk, case number 24T00108.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Mueller here on behalf of Joshua Clerk. Mr. Clerk, can you state your name?
Joshua Clerk.
Good morning, Mr. Clerk. We're here for final settlement conference.
That's correct, Your Honor. At this time, the township is not in a position to proceed to trial.
Your Honor,
As FYI, I'm letting someone into the courtroom with the phone number only.
Oh.
We find out who the individual is. The individual with the phone number that ends in 5835 that was just allowed into the courtroom, could you please unmute by hitting *6 and then tell us your first and last name?
Mariah Donnell for the court, Your Honor.
Mariah Donnell. Thank you, Ms. Donnell.
Your Honor, that doesn't change this case, so we're not able to proceed.
All right, please move forward. Ms. Mueller, what's your request?
yes, Your Honor, the defense moves to dismiss.
Being able to proceed, the court is going to dismiss this matter without prejudice. All your bond conditions are now over, but you should not have contact till after 5 o'clock if you had no contact conditions.
Okay, Your Honor, if I may, I have a couple questions.
Yes, sir, Mr.
With the case, I'm sorry.
Yes, go ahead.
With the bond conditions being removed and the case being dismissed, would I be able to have a copy of the document? Because then I also had another question. Would it prevent me from, out of the case dismissed, would it prevent me from getting a CPF that was originally the case in the beginning?
As to the first question, getting a copy of the document, you can come to the court and get a copy of the document, sir.
Okay.
As to the second question, that's a legal question that would require your attorney to provide you with an answer to that question.
All right.
I don't know. Well, I may or may not know the answer to that. And if I did, I couldn't give it to you anyway because I'm not allowed to give legal advice. Okay.
Understood.
Who's his attorney again? Ms. Mueller, you want to talk to him in the breakout room, Ms. Mueller?
Your Honor, I think I've answered it. My advice was to obtain the first. So I think if he obtains that, my advice was that that should be sufficient. So Mr. Clerk, I would just advise to get that official copy of the dismissal, okay?
Understood. Thank you. Am I all set to leave?
Yes, you are, sir. Have a good day.
You as well. Thank you.
Bye-bye. The clerk will call the matters of Mariah Donnell. Case numbers 22W004171, 20S00501, 21W001738B, 21W001738C, and 24S00017.
Rachel McDuffie for the people.
Assistant Public Defender Don Filippo for Ms. Donnell. Ms. Donnell, could you say your name?
And Your Honor, Olga Yarmolenko on behalf of Ms. Donnell, and in case ended with 00017.
Thank you. And that is the only one that's on for final settlement conference today. We do have 22W004171 that's on for pretrial, but that's for driving while license suspended. The others are show causes.
That is correct, Your Honor. Would you like me to go first or Ms. Yarmolenko?
Why don't we deal with the final settlement conference first, Ms. Yarmolenko?
Your Honor, with respect to the final settlement conference, the people are unable to proceed.
Motion to dismiss.
All right. As to case number 24S00017, that case is now dismissed, Ms. Donnell. That case, because there are a number of them, is the larceny less than $200. People are unable to proceed, so that is now dismissed. Having said that, now and you are excused, Ms. Yarmolenko. Thank you for your patience today.
Thank you, Your Honor.
With respect to the driving while license suspended case, Mr. Lebo.
Thank you, Your Honor. I did discuss this with Ms. Donnell. Ms. Donnell tells me that she has not yet been able to make any payments in an effort to get her license restored. It's still in her intention to do so. What she tells me is that she had a change in employment and she just started a new job at the Black Rut restaurant a few days ago, and that she needs to save some money so she can make some payments, and therefore we're requesting a 30-day adjournment in all of these remaining matters.
Anything from you, Paul?
Paul Barnett on behalf of the township, no objection.
And then the other cases, the rest of those, I think the one that Mr. Duffy is on is just a show cause for payments.
Yes, Your Honor, we'd be having the same request.
Oh, okay. All right, we'll adjourn this matter to July 11th, 2024 at 10 a.m. at 9 a.m.
Thank you, Your Honor.
Just gonna keep. Mm-hmm.
You're okay, Ms. Darnell. You may be excused. We'll see you on July 11th at 9 a.m.
Okay, thank you, Your Honor.
Thank you. Bye-bye.
Bye.
And take it out.
Yeah, I'm gonna take it out. Okay.
State of Michigan versus Kadena Jackson, 23S00353, recall.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Kadena Jackson. Ms. Jackson?
Ms. Kadena Jackson, please unmute, state your name again. Passing that matter to the end of the docket. Ypsilanti Township versus Lisa Flick, case number 23T00118.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Mueller here on behalf of Lisa Flick. Ms. Flick, can you state your name for the record, please?
Lisa Flick.
Yeah, we're here for final settlement conference. At this time, the township is not in a position to proceed to trial.
Your Honor, defense moves to dismiss.
Thank you. Defendant, Ms. Flick, for people who are not proceed, I'm going to grant your attorney's motion to dismiss. The motion is granted without prejudice. What that means is if they're able to proceed at a later date and time, then this case could be reauthorized. Do you understand that, ma'am?
Okay.
All right, thank you. You're all
Thank you.
set.
Thank
If there are no contact provisions in place, which there are, you should not have any contact until after 5 o'clock today once the lien has been reached, okay?
Okay, thank you.
Ypsilanti Township versus Roderick Gaston, case number 24T00030.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lieb on behalf of Mr. Gaston. Mr. Gaston, could you please unmute and state your name, sir?
Roderick Gaston.
Thank you. We're here for a final settlement conference today.
That's correct, Your Honor. At this time, the township is not in a position to proceed to trial.
Your Honor, at this time, the defense will move to dismiss.
The motion is granted without prejudice, sir. So all your bond conditions are now over. This case is closed. There was no money that was posted in this case. Do not have contact until after 5 o'clock today, okay?
Thank you.
You're welcome. Have a good day.
You too.
I need a translator on this one. All right, we're waiting for a translator. In the next case, I'll call one in the interim time period. Ypsilanti Township versus William Hollins, case number 22T00864.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of William Hollins.
Mr. Hollins, please state your name. You need to unmute the device, sir. I'm going to send you a button. Please hit that button. Did you hit the button? Hit the blue button, sir.
That's it.
All right, please state your name.
William Eugene Hollins.
Thank you. Today's the time scheduled for final settlement conference.
That's correct, Your Honor. At this time, the township is not in a position to proceed.
Your Honor, I will make a motion to dismiss.
All right, given the people are unable to proceed, I'm going to grant your motion to dismiss this without prejudice, meaning that if they are able to proceed at a later date and time, they could reauthorize. Sir, please don't have contact until after 5 o'clock today when all the conditions will be taken out of lien. This case is not closed.
Thank you. Thank you. And you have a blessed day.
Thank you, you too, sir.
I'm done.
Yes, sir, you're all set. Have a good day. You have a translator yet? Miss Victoria, please unmute your device. Oh, there you go. Please
Good morning.
Please put your credentials on for me, please. Good morning.
Yes, my name is Victoria, ID 258069.
Thank you. Please raise your right hand to be sworn. Do you swear or affirm that you will translate from English to Spanish and Spanish to English to the best of your ability?
Yes, ma'am, I swear.
Thank you. Court will call the case of Ypsilanti Township versus Brian Hernandez, case number 20T00390.
And what is the first name? I got Brian Hernandez, but I didn't catch the first.
That was Brian.
Si tenemos el caso de Brian Hernández con el caso número 20T00002.
Okay.
Okay.
Paul Barnett on behalf of the township.
Paul Burnett, de parte del pueblo.
Assistant Public Defender Davi Liba on behalf of Mr. Gonzalez Hernandez.
Tenemos lo que es el defensor Libam de parte del señor González Hernández.
Thank you. We're here for final settlement conference today.
Y estamos aquí para lo que es la conferencia final el día de hoy.
That's correct, Your Honor. At this time, the township is not in a position to proceed.
Es correcto, su señoría. En estos momentos lo que es el municipio no está dispuesto a continuar.
At this time, the defense would move to dismiss.
I couldn't hear it, sorry.
The defense moves to dismiss at this time, Your Honor.
Sí, en este momento el defendido puede ser despachado.
Given that the people are not able to proceed, I'm going to grant the defense's motion to dismiss without prejudice.
Así en este momento, ya que no se puede proseguir, vamos a quitar lo que es la moción sin prejuicios.
What that means, sir, is if they are able to proceed at a later date and time, they could reauthorize this case.
Lo cual esto quiere decir, señor, si lo quieren hacer para otra fecha y hora, pueden continuar con este caso.
All your bond conditions are now over and you may be released once the paperwork is sent over to the jail.
Sí, ahorita lo que es su fianza, se puede ir una vez que todos sus documentos se lo envíen a lo que es la cárcel.
Your Honor, if I may just provide some information to Mr. Hernandez. I believe he's actually being held on one other matter as well as a federal hold.
Sí, creo que ahorita el señor Hernández lo tienen detenido por un caso federal.
So therefore, sir, you won't be released because there's other matters holding you.
Sí, señor, entonces no lo van a dejar ir debido a que hay otro caso que lo está deteniendo.
Have a good day, sir. You're all
Que
set.
tenga buen día.
Yes. Thank you.
Bye-bye. Thank you, Victoria.
You have a good day.
The court will call the matters of Romello McIntyre, case numbers 23 FB 1537 and 24 S00052.
Richmond, Deputy for the People.
Assistant Public Defender Davi Liba for Mr. McIntyre. Mr. McIntyre, can you state your name, sir?
Romello McIntyre.
And Edward Drucas for Romello McIntyre in the 1537 matter.
Thank you. We're here for final settlement conference on both of these matters.
Your Honor, I don't believe the people are able to proceed at this time.
I'd move to dismiss 1537.
As do I, Your Honor, with regard to 00052.
Thank you. Given that the people are unable to proceed, I'm going to grant the motion to dismiss in both cases. They are without prejudice, meaning that if they're able to proceed at a later date and time, these cases could be reauthorized. Do you understand that, Mr. McIntyre?
Yes, Your Honor.
All right. Do not have, let's see here. There was a no contact in that one. I'm not sure why, and I guess they were both. So there's no contact provisions. You need to honor those provisions until after 5 o'clock today, okay?
Yes, Your Honor. I have a question, Your Honor.
You're on tether, home confinement? Yes, you can, go after 2:30, you think? 3? Okay, go after 3 o'clock today. You can go after 3 o'clock to get your tether removed, okay?
Okay, thank you, Your Honor.
Was that your question?
Yes.
All right, you're all set. Thank you, sir. Have a
Thank
good
you.
day.
Thank you.
State of Michigan versus Stephen Moss, case number 24S00083.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Stephen Moss.
Mr. Moss, please unmute, state your name.
Stephen Moss.
We're at the final settlement conference today.
Your Honor, it looks like the people are unable to proceed at this time.
The defense will make a motion to dismiss.
Given that the people are unable to proceed, the court will grant the defense's motion to dismiss. The dismissal is without prejudice, meaning that if they're able to proceed at a later date and time, the case could be reauthorized. Case is now over, sir. And all your bond conditions are now over. Please honor them until after 5 o'clock today, once it can be placed in lien and be taken out of the system, okay?
Okay,
All right, thank you. Have a good day, Mr. Moss. State of Michigan versus Jack Mullins, case number 23S00298.
Your Honor, it sounded like it cut off right after you said the M. I didn't hear the case number, so I wasn't sure if you had
See,
stopped. Or...
okay. The court will the case. I was wondering why everybody was quiet. I'm like, I know I called the whole case. State of Michigan versus Jack Mullins, case number 23S00298.
Rachel McDuffie for the people.
Okay, I'll take it. Assistant Public Defender Sandra White on behalf of Jack Mullins.
Mr. Jack Mullins, please unmute your device, turn on your screen, and state your name.
Jack Mullins.
Thank you so much. Good morning, sir.
Hello.
We're here for final settlement conference today.
The people are unable to proceed at this time.
Your Honor, we make a motion to dismiss.
Thank you. Given that the people are unable to proceed, I'm going to grant your motion to dismiss Mr. Mullins, meaning what that means for you is that if they're able to proceed later, they could reauthorize it. But all your bond conditions are now over. You had no unwanted contact, so you should be fine with continuing the no unwanted contact until after 5, and then you don't have to worry about it, okay?
Okay, thank you very much.
You're welcome. Have a good day.
You too as well.
State of Michigan versus Timothy Rogers, case number 23S00445.
Virtually different people.
Assistant Public Defender Sandra White on behalf of Timothy Rogers.
Timothy Rogers.
Thank you. We're here for final settlement conference today.
Your Honor, I don't believe the people are able to proceed at this time.
Your Honor, the defense would make a motion to dismiss.
Given that the people are unable to proceed, the court will grant your motion to dismiss. The dismissal is without prejudice, meaning that if you're able to proceed at a later, if they are able to proceed at a later date and time, they could reauthorize this case. It looks like there was a no contact except for consensual, so you can have consensual contact like you were. So please honor the conditions until after 5 when they should be removed from lien. Okay?
Okay.
Have a good day, sir. You're all set.
Thank you.
State of Michigan versus Jason Roth, case number 24S00058.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Jason Roth.
Mr. Jason Roth, please unmute your device and state your name.
Jason Roth.
Thank you. We're here for final settlement conference.
That's correct, Your Honor. I don't believe the people are able to proceed at this time.
Defense would make a motion. Defense would make a motion to dismiss.
Given that the people are unable to proceed, I'm going to grant the defense's motion to dismiss. It is without prejudice, meaning that if they're able to proceed at a later date and time, it could be reauthorized. Sir, all your bond conditions are now over. In this particular case, please honor the conditions until after 5 o'clock today. Okay? And then it should be out of the lien system.
Okay, thank you.
Have a good day.
You too.
Bye-bye. State of Michigan versus LaShawn Taylor, case number 24S00015.
Rachel McDuffie.
Assistant Public Defender Sandra White on behalf of LaShawn Taylor.
LaShawn Taylor on the behalf of LaShawn Taylor.
Thank you, Mr. LaShawn Taylor. Today's day and time scheduled for final settlement conference.
That's correct, Your Honor. This is a case where the people will be planning to proceed with or without cooperation from the complaining witness, especially given the circumstances and this assault apparently taking place during the 911 call. However, the officer that I would need as a necessary witness in this case has informed us that he is, one moment, I just want to get the dates. I believe it has family leave, and let's see, he's not yet going. He'll be going in about the next week and returning on about August 15th. So if we are not able to request to be placed on the jury selection docket, I guess it would have to be the September one, which is quite a bit in the future. Then if we're forced to dismiss, or rather if defense is able to dismiss at this point, then we would just have to reauthorize it as soon as he returns so we can proceed to trial.
Ms. White, what is your position? They're requesting an adjournment. The reality is that you could be on our August 9th selection and pick a date after that.
That's true.
I would say any delay, we would make a motion to dismiss.
I understand. All right, the motion to dismiss is denied. I'm gonna put this on our August 9th jury selection date. The motion is granted for the delay, August 9th, 2024.
Thank you, Your Honor.
At 8:30 a.m. for jury selection. We'll see you all then.
Thank you, Your Honor.
Yeah. Ypsilanti Township versus Brandon Kierdorf, case number 24T00107.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Mueller here on behalf of Brandon Kierdorf. Mr. Kierdorf, can you state your name for the record, please?
Yes, Brandon Kierdor.
Thank you. Good morning, afternoon now, Mr. Kirdor. We're here for a final settlement conference in this case.
That's correct, Your Honor. At this time, the township is not in a position to proceed to trial.
Your Honor, defense moves to dismiss.
Given that the people are unable to proceed, I'm going to grant your motion to dismiss. The motion is without prejudice, Mr. Kirdor, so that means that they could reauthorize it if they were able to proceed at a later date and time. As of now, this matter is dismissed and all of your bond conditions are now over. Please honor the bond conditions until after 5, when it can be removed from the lien system.
Thank you, Your Honor.
You're welcome. Have a good day, sir. Ypsilanti Township versus Andrew White, case number 24T0000006.
Paul Barnett on behalf of the township.
Good afternoon, Tina Sachs on behalf of Mr. White.
Hello, Ms. Saxon.
Mr. White, please state your name for the court.
Name is John White.
Thank you. We're here for final settlement.
That's correct, Your Honor. I did have a chance to speak with the victim. She's actually here today. And based on my conversations with her, we're not in a position at this time to proceed to trial.
Your Honor, I would move for dismissal and ask that it be dismissed with prejudice so that this case cannot be brought again in the future.
Your Honor, I don't believe it's appropriate to dismiss it with prejudice.
Thank you. The motion to dismiss is granted as to the dismissal itself. As to the with prejudice, I am not in a position to grant it with prejudice. I don't know the basis for the prosecutor's decision not to move forward at this time. However, if they do find that there's a method by which they can move forward, there's nothing here that would grant a with prejudice. The jury has not been sworn, and this is the first authorization of this case. So that part is denied.
Thank you.
Your Honor,
I'm sorry, Ms. Saxon.
my client is watching a trial and it will be dismissed.
We can't make out what you're saying. It's not going to be recorded on. You have a very bad connection right now for whatever reason, Ms. Saxon.
Is this better?
Not at all. It's worse.
My client is against my advice asking for a trial if the case cannot be dismissed. If the case will not be dismissed with prejudice.
Well, he can ask for that. That's fine. But it is denied. The case is dismissed.
Thank you.
You're welcome. All your bond conditions are over, sir. Please honor them until after 5.
Okay, thank you.
Ypsilanti Township versus Michael J. Jacobs, 24T00040. I guess I'm breaking up too, because no one is answering. Ypsilanti Township versus Michael Jacobs, 24T00040.
Paul Barnett on behalf of the township.
Assistant Public Defender Don Philippe on behalf of Mr. Jacobs. Mr. Jacobs, can you please unmute, turn on your video, and state your name, sir?
Mr. Jacobs?
I'm sorry, I was trying to figure it out.
Just state your name for us right now, and you get your video turned on afterwards.
Michael Jacobs.
Thank you.
Yeah, we're here for a final settlement conference. At this time, the township is not able to proceed to trial.
Thank you.
Your Honor, the defense would move to dismiss at this time.
Given that the people are unable to proceed, I'm going to grant your motion to dismiss this without prejudice, meaning that if they're able to proceed at a later date and time, it could be reauthorized. Sir, all your bond conditions are now over. Please honor them until after 5 o'clock today, when you can have the contact. We don't want you to get picked up when it's not in the lien system yet. It should be in the lien after that time. Okay?
Okay, thank you.
Have a good day, sir. Ypsilanti Township versus Malik McCullough, 23T00773.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of Malik McCullough.
Please state your name, Mr. McCullough.
Malik McCullough.
Thank you. We're here for final settlement conference today.
That's correct, Your Honor. At this time, the township is not able to proceed.
Defense will make a motion to dismiss.
All right, given that the people are unable to proceed, Mr. McCullough, the matter is now dismissed. This without prejudice, meaning that if they're able to proceed later, they could reauthorize it. Do you understand that, sir?
Yeah, okay.
All right. Thank you. Have a good day, sir.
Stop scamming people.
Sorry, what?
He said, stop scamming people.
Ms. McDuffie.
I'm just trying to help. I want to make sure the court has complete information, Your Honor.
Mr. McCullough. He's still here. Ms. White. You just muted. Your client is still here. First of all, he's not responding to me. And secondly, he just made a very derogatory statement.
I am here. I am here, still here.
What did you say, Mr. McCullough?
I said, y'all stop scamming people.
Who's scamming someone that you're talking about, sir?
That ticket I just paid off.
Mr. McCullough, do you want to be held in contempt of court today?
No, for what?
For being disrespectful to the court.
Oh, okay. I'm sorry, court.
Mr. McCullough, it's in your best interest to leave.
We done? Did y'all get that money back?
We don't have to be done. And if we're not, it's not going to be in your best interest.
I got that money. Did y'all got the money I paid, all right? Can you tell me that? The zero balance I got on that ticket that you was talking about last time?
Mr. McCullough, in just 1 second, I'm going to retract my dismissal of this case and have you come in for a contempt proceeding. Do you want that?
No, I don't want that. I just asked a question about if y'all got the fee
Oh,
that was.
you have a question.
Ms. McCullough, it's my advice that you leave the court now.
Are we done? Okay. No more court dates?
The case has been dismissed.
All right, peace.
My apologies.
It's your name. Thank you. You're welcome. One moment, please. All right, the court will call the case of Ypsilanti Township versus Ronald Hamilton, 23T00835.
Paul Barnett on behalf of the township.
Ronald Hamilton.
Thank you. Good morning, Mr. Hamilton.
Sorry about that. I pushed all the wrong buttons. Assistant Public Defender Sandra White on behalf of Ronald Hamilton.
Thank you. We're here for final settlement conference today.
Yes, Your Honor. Defense is coming to some additional discovery that we would like to share with Mr. Barnett. And after speaking with Mr. Barnett, we would like to ask the court if we could set this back to a pretrial.
Yeah, I would join that request, Your Honor. There's some interesting information that she's come up with, and there's some other issues that I need to discuss with Ms. White about the case. I think we're going to resolve it one way or the other, short of a trial.
Can I see you guys in the breakout room, please? All right, in this particular matter, there's been a request to take this back to the pretrial stage for there to be a review of the records that have come in and some additional second looks at this matter. I will adjourn this matter back to the pretrial stage for June 26, 2024 at 9:00 a.m.
Thank you.
Thank you, Your Honor.
You're welcome.
Thank you.
Have a good day, everybody.
You too. Bye.
Bye-bye. Bond is continued. That is the final subject.
He told me to hold on that one for a second. Oh, no.
All right, the court will call the matter Ypsilanti Township versus Joseph Bailey, 24T00118.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Mueller here on behalf of Joseph Bailey. Mr. Bailey, can you state your name for the record, please?
I believe that's Joe's iPad, Joseph Bailey. Please unmute your device and state your name.
I'm sorry, Joseph Bailey.
Thank you. Good afternoon, Mr. Bailey.
Good afternoon.
We're here for final settlement conference.
That's correct, Your Honor. We're ready to proceed to trial.
Ms.
Yes,
Muller?
Your Honor, we would like to set this matter for a jury trial.
It's already set. All right, so that means that we're doing this selection and it's the only one we have so far. So I hope you mean what you say when you say you're ready to go to trial, because I'm going to be very upset if this is the only case that's on the docket that day and it's not going. So there are no offers after today.
And just so it's clear, we did make an offer today for a plea under 4A.
And Your Honor, I did speak with Mr. Bailey about what 4A means, what that entails. And Mr. Bailey, is that your final decision? You do understand that this is the last chance to, if you wanted to accept that offer?
Yes,
And you want to proceed to trial?
yes.
Jury selection in this case will be, and is already scheduled for June 7th, 2024 at 8:30 a.m. That is in person, sir. Please be on time. Bond is continued. We'll see you now.
I just had one question. I don't know if my
Mr. Bailey, can I give you a call after court if it's okay? I think I know what your question is, but can we talk about it after court?
okay.
I'm sorry, if that's okay. I would just like to speak with Mr. Bailey about.
Do you want to talk to him right now?
I don't need to. Well, I don't need to, but I could. If the court would like to put me in a breakout room, that's also fine, Your Honor.
And I only want to do what you want. So no.
I'll give him. Well, okay. I'm sorry.
Okay, it's all right. She could call me. It's all right.
Okay, I'll give him a call.
That's fine. Just give me a call. She probably already has the answer to my question anyway, so I won't bother the court.
All right. Thank you, sir. We'll see you then. Okay.
Yep.
The court will call the case of the state of Michigan versus Kadena Jackson, 23F00353. This is my last time calling this case. If she doesn't respond, a bench warrant will issue.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Kadena Jackson. Ms. Jackson? Keep seeing parts of her. There she is. Ms. Jackson, can you state your name? Hopefully she's trying to get.
I do apologize, ma'am. This is Kadena Jackson. I'm here on behalf of 14B Court District in court. Can you hear me?
Yes, ma'am, I can. Ms. White, where are we with this, please?
Yes, Your Honor, we did look into this matter and we do have a conflict. Our apologies.
Okay.
We do need to withdraw from this case.
I can say, if it makes it any better, that this is the same officer that's going to be on leave that I mentioned in the other case. So we probably would have needed more time anyway for him to return. Or rather that this case wouldn't have been able to go until August at the earliest. So I suppose it works out somewhat.
All right. So you'll be filing your motion to withdraw. Can you do that timely within this week, Ms. White?
Yes, I will send the message out today.
I'll put it on June 20th for the pretrial at 9 a.m. Hopefully we have a new attorney by then so she can have her new counsel and we can go from there. Thank you.
Thank you.
Is this the Barnwell thing?
Correct. So I believe that was the end of
Thank you, Your Honor.
You're welcome.
Thank you. So what do I do now?
You have to wait for your attorney to reach out to you, Ms. Jackson. Your new attorney will reach out to you.
Okay, what does she mean by officer?
She's saying that there's a police officer that's going to testify in this case, and that police officer is not available to go to trial until August anyway. So this doesn't change really anything that was going to occur in your case. That's what she. Okay.
Yes, ma'am. Thank you so much. I appreciate your time, Ms. Washington. I apologize.
That's okay. Have a good day, Ms. Jackson.
You too. Yes, ma'am.
State of Michigan. State of Michigan versus Amari Bigham, case number 20FB 1514.
Rachel McDuffie for the people.
Good morning, Your Honor. Or good afternoon, Your Honor. Wendy Burnwell on behalf of Miss Amari Bigham.
Thank you. Ms. Bigham's been here all morning. Is she still here now? She is.
Yes, I think she is.
Please unmute your device and state your name.
Amari Bigham.
Thank you. All right. Ms. Begum this is a motion that you filed.
Yes,
Requesting
Judge.
for the arrest record for Ms. Begum.
Yes, Judge. I had asked Judge, oh my goodness, I forgot the judge's name.
Simpson.
Yes, yes. I had asked the judge in 14 A1 to if he could enter that order on the day that it was being dismissed, and he said something about the clerk would have to do that, and then it wasn't done. So I subsequently filed a motion, and I don't know if you would just amend the order that already exists to reflect that.
No,
Or do you
there's
need a brand new one?
a separate form you have to fill out. If
Okay.
granted. Ms. McDuffie.
Your Honor, I don't see anything that would make this case ineligible for what she's requesting, so nothing from the people.
I think that maybe if you have to do this in the future, the best way to do it is to do a stipulated order with the prosecutor's office if they're willing to do that, so that therefore your client, you don't have to wait. But I am going to need, there's a form that does it, or you can prepare your own separate order that destroys the records.
I'll do that within an hour.
Okay.
Now, who would I send it to? Would I send it to Miss McInnes?
No, I'm not sure who that one is, but you would send it to Miss Ball. Miss Ball. Send it to Miss Ball.
Heather Ball?
Yes, please.
Okay.
Thank you.
Thank you, Judge.
You're welcome. And CC Ms. McDuffie on it.
Yes, thank you.
And the clerks, please. Well, it's something else. So, send it. Actually, they want you to send it directly to the clerks, and then you can CC Ms. Ball in case something goes awry.
Okay, thank you.
Thank you.
Thank you, then. Bye-bye. Have a good day, everybody.
Bye-bye.
Yeah.
All right.
All right, finally calling failure to appear. State of Michigan versus Paris Bryant, 21S00425.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Paris Bryant. Ms. Bryant had exams and was going to try and Zoom in.
Well, Ms.
but she
Bryant
didn't-
made payments. She made a
Yes.
payment. She made payments of $150.
Yes.
And then she made another payment of $100. It looks like, yes. So she made payments of $250.
Okay, so the 150, okay.
August 29th, 2024 at 10 a.m. State of Michigan versus Levert Mentor, case number 17-00141.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Levert Mentor.
Mr. Has he made any payments? Mr. Barnett, all your cases are done, I'm pretty sure.
Yeah, I think so.
Thank you. Have a good day.
Mr. Mentor believes this, and I looked, his payments appear to be up to date. He just needs to make his May payment, which he said he will do tomorrow. And he did not plan to appear.
All right. It appears that's true. A August 29th, 2024 at 10 a.m. Postman. State of Michigan versus Delonte Napier, case number 24 FB 1007.
Rachel McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Delonte Napier. Your Honor, I did not get a hold of Mr. Napier. I did leave a voicemail asking him to call me back, but did not hear back.
Hold on 1 second, please. All right, yes, Mr. Napier has failed to appear today, it appears. And apparently he has a new case too. So, bench warrant to issue for Mr. Napier, no bond. For the record, he's supposed to be here for his first review. On his probation. Doesn't appear to be going well at all. State of Michigan versus Felicia Jernigan, 23S00807.
Rachel McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Felicia Jernigan. Your Honor, I have spoken with Ms. Jernigan. I did remind her.
Ms. Muller, 1 second. Seems to become more frequent.
It's when we have long stretches where we don't recess. We're back on. Also, I received some type of, and I can't print it. It's a JPEG.
Can you forward it to me, please?
I can definitely.
On Ms. Jernigan?
Correct.
All right. Apparently the reporter has received, who did it come from?
Ms. Moore.
Oh, received something you sent to her, Ms. Muller. What is that?
That is a letter. So Ms. Jernigan was with her therapist today at home with New Vision. I asked her to get confirmation that she's on the wait list. So that letter is confirmation that she's in outpatient. She's on the wait list for inpatient with a tentative date for June 7th. So that's what she sent over this morning from her therapist at home of New Vision.
And you sent that to Ms. McDuffie as well?
I thought I did. I'm sorry. Okay.
Well, the problem is that she has a bond violation. She hasn't been testing. She hasn't tested since April 19th. She missed April 19th.
Oh, she tested because she blew a 0.1. I'm sorry, Your Honor. I just wanted to make sure you had the one that came in this morning.
The one it says she missed April 19th, April 30th, and May 21st. Whoa. Oh, that's drug testing. Wait, let me see the rest of this. And then the sober link. On May 28th, which was yesterday, she blew a 0.18118. So I'm glad that she has a plan to get into home of New Vision. Let's hope she does that before she gets picked up on this bench warrant I'm about to issue.
And Your Honor, her warrant is still active because when the last time she got arraigned, I put a request in to the magistrate and copied all the PDs on it that she not be released on PR again, that her warrant basically remained. But I think is it 20K, 10%?
Yeah, that's what I had it at, but she was arraigned. Oh yeah, the bond had continued.
Can it be a higher?
Yeah, I'm gonna change that to what is this? She is at the pretrial stage. You asked to have it revoked back in March, I believe.
I sure did.
I wrote down, I did not do that over your objection, but I don't think I can revoke bond when they're at the pretrial stage like that. I can set a high bond So what I'm gonna do is set a $50,000 cash or surety bond. All right.
Your Honor, I know it's been a very long docket. I'm sorry. I have one brief thing if I could bring up on the record. I promise it'll take a minute or two, but it is kind of an emergency, so I wanted to raise it now.
Okay,
If that's okay.
let's see what you think of as an emergency. Go ahead.
Well, I sent a motion earlier this week. I do want to retract part of the motion. It's about Aaron Pacini's case. I had sent a kind of an alternative and or motion to have his tether removed or change the address. At this time, I'm just asking if the court could change the address today. There's a situation, I don't want to get into too many details with his roommate, but police have been called last night and it's been an ongoing situation that I've been aware of. Nothing to do with Mr. Pacini, but with his roommate. And it's becoming, I think, very, very unsafe. So I just wanted to see if the court could approve his GPS address to be changed. He's secured new housing in Ann Arbor. I sent the address on the order I sent over. I can revise the order so that it's just the change of address. I do believe Ms. McDuffie is in agreement to just have the address changed for his GPS tether. If I'm not false, or Ms. McDuffie, I'll just let you speak for yourself.
Is that correct, Ms. McDuffie?
That's fine, Your Honor. And Ms. Moeller. Ms. Moeller, you seem like more stressed today than I've ever seen you, so I know this is important.
So it is about order the defendant's bond be modified. To changing defendant's home address of his GPS tether to the new address is what I did. I crossed out the other part.
Yes, thank you.
All right. I'm sorry?
It's the correct address that it needs to be done to.
Mhm.
Okay. Wanted to make sure, because
It's the Yoast where you're talking about, right?
Correct. Yep. Yep.
All right, I've signed that.
Thank you so much.
You're welcome. Anything else stressing you out that I can help you with?